Phil Silberman from the Silberman Law Firm here today, and we are talking about a deed of trust. In Texas, we don't have mortgages. We have a security instrument that affects a lien on real property, and we call it a deed of trust. This gets recorded in the real property records. It's part of a whole document set when you're doing a real property financing package. So you typically have the warranty deed with the vendor's lien. Then you've got the promissory note, and then you've got the deed of trust. And today we're going over the deed of trust. So let's get started. First thing, notice of confidentiality rights. This notice should go on almost all real property record filings to be recorded. And you've got the title of the instrument. It's a deed of trust. And then you get into your basic information. The date of the deed of trust, the grantor. So remember, in a deed of trust, the grantor was actually the grantee on the deed, because in the deed of trust, the new owner, who was the grantee on the deed, is the grantor on the deed of trust, granting a security interest back to the lender. So just remember that. Grantor's mailing address. The trustee is usually a lawyer. In this case, I put myself. Remember that if you're the lawyer representing the lender or the seller, for example, in an owner finance transaction, it's okay for you to be the trustee. If you're the lawyer representing the grantee or buyer in the transaction, or the borrower, then you should not ever list yourself as the trustee, because that could create a conflict of interest problem. Trustee's mailing address, lender, in this case, John Jones. You would see a bank there if it's third-party financing. It can be an individual. Lender's a mailing address, and then the underlying obligation, which is the note, the date of the note. In one important thing here, your real property documents should all have what they call dates of, or have even dates. Your deed with the vendor's lien should have the same date. Your promissory note should have the same date, and then your deed of trust should have the same date. And there are legal reasons that I won't get into as to why that's a good practice. Original principal sum of the note, in this case $100,000. You might have a down payment and then a note balance, and then the balance, the original balance of the note goes here. Again, borrower, lender on the note, maturity date of the note, terms of the payment as provided in the note. Then you've got the legal description. Any type of document granting an interest in real property has to have a good legal description in there. Remember to always use a full legal description. Don't use an abbreviated or truncated legal description from the appraisal district. Other exceptions to conveyance and warranty. Remember, this is a document that's granting an interest in real property, and when you're granting an interest, you often want to have exceptions. For purposes of the deed of trust, this exception provision matches the same exception provision on your warranty deed with the vendor's lien, which will also match the exception provision on your earnest money contract. In this case, it was the Texas Real Estate Commission promulgated 1-to-4 single-family form. So this is the TREC exceptions in the contract, transferring over to the deed and now transferring over to the deed of trust. Granting clause, you always have to have a granting clause if you're granting property. In this case, the grantor is granting the interest to the trustee to be held in trust until the underlying obligation, the promissory note, is paid in full, at which time the lender is then obligated to sign a release of lien, releasing both the vendor's lien and this deed of trust. Grantor's obligation. So if you're the borrower on a property, you've got to do some basic things. You have to maintain property insurance. You have to pay all the real property taxes on it. You've got to keep the property in good repair, things like that. Lender's rights. So the lender has the option to appoint other substitute trustees. Typically, the original trustee on a document on a deed of trust, does not end up doing the actual foreclosure. Let's say years later, the borrower defaults. that lender will oftentimes hire a different lawyer to do the foreclosure, and then there'll be an appointment of a substitute trustee that will then go forward with the foreclosure. If the big thing here is the lender has to perform certain obligations. The grantor has to perform certain obligations, and if the grantor fails to perform any obligations, the lender can go ahead and do it and be reimbursed by the grantor, in addition to other rights that the lender will have. If a default exists on the note, so if the borrower doesn't pay, the lender is going to accelerate the balance of the note and begin the foreclosure. So direct the trustee to do the foreclosure, or probably the substitute trustee. And then, of course, the lender does have the option of buying the property back at the foreclosure sale. We call that credit bid. So if there's a balance on the note of $100,000, the lender is going to get credit bid at the foreclosure sale. Trustees' rights and duties. If the borrower doesn't pay, then the lender is going to direct the trustee to foreclose on the property. So sell and convey the property as is to the highest bidder at the foreclosure auction. And then from the proceeds of the foreclosure sale, all the expenses get paid, the notes get paid, and if there's any left over, that goes back to the record title holder. So if any of the property is sold under the deed of trust, so if there is a foreclosure, the borrower, the grantor, needs to surrender possession to the purchaser. If the borrower, grantor, the buyer, the person who's in the property doesn't do that, then that person's going to be, the grantor is going to be attended at sufferance. There'll be an eviction. The new buyer at the foreclosure sale, whether that's the lender or a third party buyer, is going to institute an eviction proceeding. So the grantor is also going to make some assignments here. The borrower is going to assign to the lender proceeds in the event of condemnation. So if the property is condemned and money is given to the grantor for value of that property, this note is going to get paid off first, and then any excess is going to go back to the grantor. And the grantor is also going to assign rent. So in the event of a default, the rent payments from any tenants in the property is going to go first to the lender to pay off the obligations of the grantor borrower. Here's E8 is what we call a usury savings clause. So this deed of trust is not going to exceed the maximum amount of non-usurious interest. If there's some type of mistake, then what's going to happen is any excess that would be considered usurious would pay off the principal balance. So usury savings clauses in Texas are enforceable. And then moving right along, this is what we call the due on sale clause. You hear a lot about due on sale clause. This is a common clause. It's basically if the grantor transfers the property to somebody else while the note is being paid, while the note is still outstanding, the lender has the option to call the note immediately due. Note that it's permissive. The lender may call the note due. Very rarely do you ever see performing notes called due because the property has been transferred. Typically it's permissive, and the lenders just aren't set up to comb through the real property records and try to find when properties are transferred. And then continuing on, this is a full recourse deed of trust, meaning the borrower or the grantor has full recourse liability. So if the note's not paid and the property is foreclosed on and that foreclosure doesn't cover the total balance of the note, the lender has the option of going after the borrower or this grantor in an additional lawsuit for the remaining balance, and sometimes that does happen. Okay, and then this This deed of trust is also secured by a vendor's lien. We talked a little bit about the warranty deed. So there should have been, in this type of transaction, there's a warranty deed. And that warranty deed will also include a vendor's lien. That's an independent lien apart from the deed of trust. So if you're thinking about belt and suspenders approach, if there were a problem with the deed of trust, the lender would have the option of foreclosing on the vendor's lien in the warranty deed, independent of the deed of trust. And by that same logic, the lender can, of course, foreclose doing a non-judicial foreclosure using the powers within this deed of trust. As a side note, if a lender wants to foreclose on a vendor's lien, which is very, very rarely done because normally the deed of trust is sufficient, that lender would have to pursue a judicial foreclosure, which is a much more expensive process. And then we get to the end where the grantor or the borrower has to sign this deed of trust. All real property records need to be recorded, needs to be acknowledged in front of a notary. The county where the grantor is signing goes here, the date, and then you'll have a notary stamp. Below here, you've got the information about where this deed of trust was prepared. In this case, we had the sample agreement we have, it was prepared in our law office. And then after recording where to return, deeds of trust usually get returned to the lender because it's a document providing security for the lender, and the lender is the beneficiary of this deed of trust. So that brings us to the end of the Texas deed of trust form. Hopefully this video was educational and you learned about Texas deeds of trust. If there's anything else you want to see discussed, please comment on the YouTube channel. Let me know. Remember to like and subscribe, and I appreciate you watching. Phil Silberman with the Silberman Law Firm signing off.